Hello, my name is Cesar Pereira. I'm a chartered arbitrator and fellow of CIARB, and it's my pleasure to welcome you again to CIARB Brazil Moment. And together here with my colleague Cristina Mastrobuono, also a fellow and vice chair of the Brazil branch of CIARB, we welcome Dr. Ilka Beimel for a discussion about her recently launched book, Independence and Impartiality in International Commercial Arbitration. Um, as you may understand, that is a topic that is very much in the spotlight all over the world. We will address some issues today that are peculiar to Brazil, but as you will hear from Dr. Ilka Beimel, they are shared with many jurisdictions, and they are being discussed all over the world. It's really an honor and a pleasure to have you here, Ilka. And I would just like to give you a brief introduction about our guest. Dr. Ilka Beimel is a German qualified lawyer and associate with their complex litigation and arbitration practice in Düsseldorf in Germany. She advises and represents clients in complex cross-border disputes, in particular in corporate liability and commercial areas. Before joining NER, she acted as tribunal secretary for an independent arbitrator in several cases and wrote her PhD thesis on this specific topic of independence and impartiality in international commercial arbitration. Her book is an expansion of her PhD dissertation and benefits from all the research that she did for that work. In addition, she was a passionate Vismuti and coach, and still is a passionate supporter of the Vismut. That is indeed how I met Ilka 12 years ago in Hong Kong at the Vis East, and it was a pleasure to be an arbitrator when she was acting as counsel, as a Moody in that competition. And it's even a greater pleasure and honor to see how she became one of those big success stories of the Vis, and now is here with us, sharing her knowledge on this very important and in current hot topic in international arbitration. Without taking any more time from our guest, I would like to turn to Cristina so that we can start our questions. Thank you, Cristina, and thank you, Ilka.
Hello, everyone. Well, first of all, thank you, Ilka, for giving some of your time here. And it's indeed, as Cesar said, a very important topic nowadays, and a must-read book that will bring a lot of information for all the readers. Well, in your book, you did extensive research about legal systems all around the world, practices all around the world. So I would like to ask you first to give us a general view of your main conclusions. Did anything in your research and findings surprise you?
Thank you very much, Cristina. And first of all, briefly, thank you very much also to Cesar for this very warm welcome. It's a pleasure to be here with you and to discuss this indeed important topic, a topic that is to my heart, one could say. Coming to your question, Cristina, and probably before coming to the conclusions, let me briefly outline to you my ideas and also my approach that I took when writing the book. My idea was to analyze the concept of independence and impartiality as it is applied in international commercial arbitration. I don't see much of a need to ask the question why I wanted to do that, but even if one would like to ask that question, I think the background, and that was curious for me as well, is that there is kind of a tension and conflict of independence and impartiality in arbitration. And that is that I think the speciality of independence and impartiality in arbitration is that arbitration has a judicial and a contractual nature at the same time. The judicial nature is obvious, it's a decision-making process. And the contractual nature is also kind of obvious. In case of commercial arbitration, there is a need to opt for arbitration, usually by signing an arbitration agreement. Arbitration also provides the parties with the right to choose their arbitrator, at least also usually. Now, having said that, there is some sort of tension with the general importance of independence and impartiality. I think there is not much of a debate about this general importance. Independence and impartiality are paramount for any judicial process. In the words of the England and Wales High Court of Justice, one could say that it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. I knew that this lodestar existed and is set, and that it applies also international arbitration. But I was curious how it is exactly interpreted and applied, bearing in mind, again, the nature of arbitration, and in particular, the parties' right to choose their own arbitrator. My approach was indeed, as you mentioned, Cristina, to analyze quite a lot of case law from England and Wales, France, Germany, Switzerland, and the United States. I addressed and focused on challenges and annulment decisions or enforcement decisions, and tried to have a look at different relationships and the conduct of arbitrators, but also on more, one could say, less touched upon topics, such as whether the fact that an arbitrator had been convicted in the past would be a ground for challenging him successfully. Now, actually coming now to your question of my final conclusions, the very first would be that, and that is probably also not surprising for our audience experienced in arbitration, is that the grounds touching on a relationship of the arbitrator and the party are probably more often leading to a successful challenge compared to a conduct of the arbitrator, meaning there are cases where the arbitrator picked up his phone during the arbitration hearing and was challenged on that ground for not being independent and impartial. So the grounds focusing on relationships are more successful. A second conclusion, and that is probably more focused on the applied standard of independence and arbitration, is that the nature of arbitration, being judicial and contractual, leads, in my analysis, to a balanced approach, leads to an intermediate standard of independence and impartiality. That being said, it means a mixed objective and subjective perspective. We will deal probably with the perspective later as well. And substantive standard that is most often described as justifiable doubts. And a third conclusion that I found quite interesting and is still very heatedly debated is the obligation to disclose, and its purpose on the one hand. In my view, the obligation to disclose is to be differentiated from independence and impartiality. Its purpose is rather to inform the parties upfront, usually at least, about the arbitrator, and to enable them to make their right to choose an arbitrator or to object to one. And the obligation to disclose has thus a different standard and also a different perspective to be applied. You also asked me for some surprising aspects. It's difficult, to be honest, now from the hindsight to say what was really surprising. But giving that a couple of minutes of thought, I would say that it was at least interesting to see the development of the standard of arbitrators to be applied. For example, in the United States, where the AAA rules demanded in the past for the party-appointed arbitrators to be less of a need of independence and impartiality, whereas nowadays it is more or less common ground that all three arbitrators have to be independent and impartial. So that was an interesting fact that I was not aware of before I started my research.
Oh, I could formulate a lot of new questions now, because it is so interesting what you already brought to us. But I will give it to Cesar, because so we go on. We have a lot of other questions to ask you. Thank you, Cesar.
You're welcome.
Thank you, Cristina. And actually, I'm going to ask you something like a follow-up question that may even be one of the questions that Cristina was thinking about. And you mentioned briefly the difference between disclosure on the one hand and impartiality and independence on the other hand. And there seems to be a clear difference in standards at the time of disclosure and at the time of a challenge to of the award, for instance, due to an alleged breach of impartiality and independence. So I think that's relatively clear nowadays. But what about the lack of disclosure that is alleged in the course of the proceedings, not at the time of challenging an award, but during the proceedings? Let's say if a party requests clarification about a fact that in its view should have been disclosed or should be disclosed. For instance, as you said, potential relationships between an arbitrator and the other party or their counsel. And the arbitrator denies that clarification as being irrelevant or immaterial. What is the applicable standard in a possible challenge to the arbitrator in a situation like that?
If I'm not mistaken, I understand your question in a way that you're referring to the question, or if I may rephrase it for myself at least, whether or not non-disclosure is sufficient ground for a successful challenge. That is indeed something I had quite a deep look into, because as most of the audience is for sure well aware of the case Halliburton versus Chubb, this was quite also heated up. There was a heated debate on that topic as well. And my take is that non-disclosure as itself is not a sufficient ground for having an arbitrator successfully challenged. It is rather the question whether the underlying fact, the non-disclosed, the fact not disclosed, whether that fact meets the usual standard applied in such a case. My reasoning for this is something that I very briefly touched upon earlier, and that is that the purpose of disclosure is, at least to some extent, different from the purpose of independence and impartiality. Disclosure has the function of informing the parties, providing them with all the possible or reasonable information that is required in order for the parties to enable to actually act and make to them available their right to choose and to object. Independence and impartiality, on the other hand, have more the purpose of creating confidence and trust in a judicial process. It's a broader aspect. independence and impartiality assure that justice is to be seen, again, in the words of the England and Wales High Court of Justice. I want to stress one point here, and that is probably a bit difficult. Although I'm saying that both concepts are different, I also would say that disclosure functions in support of independence and impartiality. For sure, without disclosure in arbitration, it would be difficult to actually make justice seen.
Thank you. And just if I may, we normally talk about a duty of a duty to investigate, or a duty. We talk about a duty of curiosity, a duty to ask questions and to seek clarifications. You mentioned a concept, the idea that parties are entitled to reasonable information, or to information that could reasonably lead to a justifiable doubt of regarding impartiality and independence. Would that be, in your opinion, the standard reasonableness for the exercise of this duty of curiosity, or this duty to investigate by a party?
Very broadly speaking, yes. I mean, for sure, we are now not dealing with concrete set of laws and their interpretation, as it always is the case. If we have a concrete set of rules, we have to deal with that wording. But on a more general level, I do think, and there is case law, for example, French case law, speaking about such a duty to investigate. And it is indeed a word reasonable that brings to that, brings this kind of concept into play. The word reasonable also, in particular, with speaking about the duty to disclose, or the obligation to disclose, has also another function, and that is what I differentiate as well between, which is, I think, at least for the practice, also quite important, not to only speak about the substantive standard that actually is applied. So the question, what needs to be disclosed, only speaking about what kind of groups of cases or scenarios, but also from whose perspective we are judging whether that fact is important and needs to be disclosed or not. And this perspective, as many of you will know, is for the disclosure quite often rather a subjective perspective, but quite often, again, linked to the fact that it should be a reasonable view from the party's point of view.
Okay, thank you. Thank you very much. Cristina.
Yeah. Well, this you brought a very interesting distinction here, a very real distinction between the duty of disclosure and the purpose and the reason that we need impartiality and independence of arbitrators. Yes, but there is a link between both. Yes. Mm-hmm. My question now is about the standards what are the the different levels of disclosure. So is there a universal standard that you found that is applicable to international commercial arbitration regardless of national approaches? And here also we have this concept, in the eyes of the parties. Should this concept be understood in a purely subjective manner, or should we give also a more objective meaning to it, such as the reasonableness approach adopted by the DIS rules? Because if taken too far, this concept in the eyes of the parties, it risks really fostering guerrilla tactics or other mechanism for a recalcitrant party to undermine the proceedings with endless requests of disclosure and challenges to arbitrators. So what is the limit between the eyes in the parties and the objective requirements that give reason to challenge an arbitrator?
That are actually a couple of very interesting questions. Let me try to react to them separately. First, on the universal standard, as I said, for sure, I had a look at the concrete wording of most of the state laws and try to see whether or not and how they are interpreted. And it depends, as it always does, on the wording of the rules, laws, and guidelines that are applicable. If these rules clearly demand a certain standard and perspective to be applied, there is not much room for interpretation. And that by then, I would say it's difficult to deviate, at least if the parties did not do so with the agreement. It will be difficult to, then there's less room for interpretation and applying on a more international diverging standard. Having said that, for sure, there are rules, guidelines, and laws that do leave room for interpretation. Now, you referred to one of the concrete wordings, in fact, the wording of the DIS rules, speaking of what is to be disclosed, that facts have to be disclosed that are in the eyes of the parties relevant. And the DIS rules, or let me first of all start with that phrase, in the eyes of the parties. And coming to your question, yes, I would say that that is rather a subjective perspective. So it is questioned what the parties from their position, what they think is decisive to be disclosed. Now, the interesting aspect is that the DIS rules do include a corrective, an additional filter, one could say. And that is that only those facts have to be disclosed that are from the eyes of the parties that could cause a reasonable person in the position of a party to have doubts as to the arbitrator's impartiality and independence. So this additional filter of a reasonable person, that is quite important in my understanding. And this is clarified by the addition in the DIS rules. Having outlined that and what I already addressed earlier, let me probably add just one thing. I think that it is very important to have a subjective element, at least, in the question of what is to be disclosed. And this goes again back to what we touched upon earlier, and that is the purpose of disclosure. It is to inform the parties and to enable them to make an informed choice. And for sure, such a purpose requires to at least, as I said, to some extent, include their perspective and to see and filter what is important for them. Very briefly, to your probably third question in the line you just dropped, the guerrilla tactics. That is quite a difficult question. Probably first of all, what I at least understand under guerrilla tactics are challenges primarily used as a delaying tactic, not necessarily that a party is convinced that there are sufficient grounds for successful challenge, but the challenge is used to delay the proceedings. Your question was whether the subjective perspective on the standard of disclosure would increase the use of such guerrilla tactics. My first take, and I don't think that there must be an increase, is that there not necessarily must be an increasing risk of the use of guerrilla tactics, at least if the rules or laws would opt for a subjective approach, and the distinction between independence and impartiality on the one hand and disclosure on the other hand is well applied, meaning that the non-disclosure in itself is no ground for challenging an award. So I would say that as long as the non-disclosure in itself is no ground for a successful challenge, I would at least have the hope that counsel would see that there is no real possibility of having a successful challenge, so that there is not necessarily an increase in guerrilla tactics.
Oh, thank you. This is a very, very objective criteria, actually. Very, very interesting. Yes. Cesar, please.
Thank you, Cristina and Ilka. Ilka, again, moving forward here but following up on what you just discussed, you may have heard that there are two initiatives in Brazil. One bill in Congress, and the other constitutional remedy at the Supreme Court that are seeking to impose stricter criteria for disclosure in arbitration. The bill in Congress intends to replace the phrase justifiable doubt with minimal doubt as a disclosure standard. And the constitutional remedy at the Supreme Court intends to obtain an interpretation of the existing clause in our Arbitration Act, which is justifiable doubt, as providing for a series of mechanisms. And I will list them here just for you to understand what the discussion is. First, that disclosure is an exclusive duty of the arbitrators without any participation of the parties. Second, that duty is to be complied with considering what may be relevant in the eyes of the parties, which has to do with what you're just discussing. Third, the lack of disclosure is sufficient ground for removing the arbitrator. Also, you touched on that point. Fourth, a duty to disclose that is not limited to the grounds for recusal of judges. Fifth, the non-applicability of the IBA guidelines as an automatic set of criteria for assessing potential conflicts. And lastly, the issue of impartiality and independence as matters of public policy that are not subject to any time bar and that can be argued at any time and at any stage of the proceedings, including at the enforcement stage. So that's the scenario. Given your research and your reflections on this matter, how do you see the purposes of these two initiatives in light of international best practices? And more specifically, are you aware of any other jurisdictions where such criteria have been adopted or have been imposed by statute or case law?
That is a very interesting debate that you are referring to. Probably to take up this time your very last question, I have to say that I'm not aware currently of any statute that actually adopted these criteria concretely, but there is quite a number, or there is quite a large amount of case law that addresses a couple of these six criteria you mentioned. And I did come across a couple of these buzzwords you just mentioned. Probably starting with the very first, the matter of whether or not it is only, as I understood you, a question for the arbitrator to disclose all the information he or she has. This, to some extent at least, contradicts with what a case law, for example, from France has stipulated, that there is indeed a duty, or it's a question whether it is a duty, but there is at least some need for the parties to do investigation. And it is also a question what actually, or let me start off again. There's at one hand the question whether there is actually a duty or obligation to investigate on the parties, A. B, an alternative way is, and this is also done in a couple of cases, to argue that the standard of disclosure does not necessarily cover those facts already known to the party or that are in the public area, that are just available everywhere. Now, there's for sure a question, what is available to anyone? Is it sufficient that it is on the website of the arbitrator or not, that fact? But there are some leeway, there is some room for leeway in that regard, and that is interesting on those two aspects. The second criteria is probably not as critical, I would say, at least, as the third you just mentioned. I think this is already probably has been noticed by our audience, that I am quite not a fan, but I think it is very interesting to differentiate properly between disclosure and the standard of independence and impartiality. And having said that, the buzzword on the non-disclosure as a ground for removing arbitrator for sure directly brings me to Halliburton versus Chubb, a very recent UK Supreme Court decision that highlighted again that the mere fact that an arbitrator did not disclose a certain fact set alone is no ground for removing that arbitrator, as long as that ground itself is not does not meet the material standard of a lack of independence and impartiality. That debate was actually already quite present back in the 1970s after a United States Supreme Court decision in Commonwealth Coatings, where the majority opinion and the one of the most cited opinion that was not the majority opinion, where they concurred on the ground exactly whether non-disclosure alone is a sufficient ground or not. But to answer your question, even in that regard, the case law debated it is only case law, and there was no statute or like that was implemented on these grounds. The fifth or the fourth question is or criterion mentioned by you is quite a difficult one as well. Taking that very serious, what you just said, Cesar, I would say that there is a risk of getting rid, one could say, of the possibility that there is a waiver. And that brings me at least to the question whether or not the nature of arbitration, and that having said already, being also contractual to some extent includes the need of waiving. And having said that directly, I have to say that we have waivers also in other judicial systems, in state court systems. So I'm quite wondering where this need comes from as the argument in the constitutional remedy to have no time bar and to have no possibility of waiver. For sure, the prerequisites of a waiver have to be met, being that the party waiving has knowledge about the certain fact. But as long as that is the case, I'm wondering whether this is a really reasonable argument, or whether it would be where it would lead to actually. Another buzzword, very briefly, you addressed were the IBA guidelines for sure. I mean, they are often criticized, interestingly, although they are used quite a lot. And the IBA just recently announced that they will revise their rules. So let's see where they are heading to. And then I think it's easier probably to say whether the criticism is to be upheld or not.
Thank you, Ilka. And you know, the federal government in Brazil issued some regulations about arbitrations in which it is involved. In it, even though it doesn't mention expressly IBA guidelines, it does introduce the idea that international guidelines or international standards are to be considered for disclosure and for and for the assessment of impartiality and independence. So it's true that they're not binding, but it's also true that they are very widely used everywhere. And I just have one small curiosity, very specific one. Have you ever seen in the jurisdictions that you researched the idea of minimal doubt as being the standard for disclosure rather than justifiable doubt in the eyes of the parties?
I mean, I did come across a variety of different possible standards. One could also say that the mere word of doubt would include the fact that it does not have to be reasonable or justified, but rather probably a minimal doubt. I mean, what is a minimal doubt compared to just a doubt? I did not come across the concrete wording minimal doubt, but as I said, the mere wording of doubt. But the interesting fact is that it is then interpreted again differently. And for sure, it's always a question what the statute says and what probably the applicable rules say, either in the rules themselves or in additional set of rules like the ethical guidelines for the arbitrators or the note to the parties in an ICC arbitration. So as I said, there's quite a number of, and what I lay out in my book as well, there are a number of sources of laws and guidelines for sure in arbitration. And I'm not sure whether I came across the situation where only the wording doubt was applied actually. So I rather have to say, no, I did not come across minimal doubt. But I would say, and I would be hopeful that there is room for interpretation in case this would actually be the wording at one point in time.
Thank you. Thank you very much. Cristina?
Well, still related to this topic, it's just a comment from my personal view. It's so difficult because doubt, it complies a lot of subjective concepts. So if it's justifiable, reasonable in the eyes of the parties, since it's always in the eyes of the party, it's always so subjective that it's hardly, so using all these terms, these concepts, at the end, it's very subjective, and each case has to be analyzed considering the information and sophistication of the party and the legal system. So, but anyway, just turning our discussion not only to the arbitrators, but turning them to the experts. I would now like to hear something about your view about impartiality and independence requirements for experts. So as I understood, your book argues that party-appointed experts are not subject to impartiality and independence requirements, unlike tribunal-appointed experts. And this is a matter of weighing the evidence that is produced in front of them. So are they nevertheless required to disclose any relationships with their appointing parties so as to provide the tribunal with information for weighting the evidence? And if so, what is the legal consequence of a breach of such disclosure obligation? It's the same standard that you explain us for the arbitrators, that just the lack of disclosure is not itself a reason to challenge. Can it amount to a ground for setting aside or denying recognition to an award?
Well, first of all, that probably to clarify that and to give that some background information to our audience there, what I mean when you said that to party-appointed experts, independence and impartiality are less important in my view. I do compare party-appointed experts to witnesses of the parties, because what I do as a party with a party-appointed expert, I present to some extent my view of a certain fact that needs expertise on. Coming more to your question, and which is very interesting, the issue of disclosure in general for experts. There is, and I found that interesting, in fact, as well, there's not much in rules and laws on the disclosure requirement of experts. There are a couple of laws which are interesting, but most of them turn only to tribunal-appointed experts. For example, the German Code of Civil Procedure, and within the Arbitration Act, it only demands tribunal-appointed experts in an arbitration to disclose. Likewise, the Ciarb guidelines on experts, they require tribunal-appointed experts only to disclose. So having said that, and again, underlying that I understand party-appointed experts more like witnesses of the parties, or I treat them alike. I think what is important for the parties is to have a credible witness, expert witness as well. And it is in their interest that the expert witness is independent and impartial, because the independence and impartiality highlights the credibility of that expert. If, and that is the scenario you, Cristina, just created, if the party-appointed expert does not disclose, or first of all, whether or not he or she has to disclose, that is, from my point of view, also then a matter more of an order, for example, of the tribunal. For example, if the tribunal orders the party-appointed expert to disclose something, that can be the case. A, or B, within a cross-examination, parties' counsel and opposing counsel may question on a certain relationship. Having said that, I do think, at least on a first take, that there cannot be a ground, at least for non-disclosure merely. It is rather, again, a question of weighing of evidence, and whether or not the weighing of evidence, and with it treatment of public policy, may create a ground for annulment or alike. But the non-disclosure itself is difficult in my understanding, yeah.
Okay, thank you very much. And in this view, the Brazilian civil procedural code in this sense is very similar to the German one, because it also not requires party-appointed experts to be independent. They are like in the team of the party, so it's not expected from them. But there is a very big debate going on in Brazil nowadays about impartiality and independence for the experts. But so we mostly use these standards to the party-appointed experts. So, okay, Cesar.
Thank you, Ilka. You mentioned something about cross-examination, and I thought that was a very interesting take. Maybe the idea is to consider that more a burden of the opposing party, to raise those issues and to investigate possible relationships and cross-examine the expert and raise those topics, rather than trying to equate that with the situation of a tribunal-appointed expert. I think that as you said, that has nothing to do with grounds for setting aside or to denying enforcement. It's merely the dynamics of how evidence is produced and the dynamics of the hearing, and it's up to the opposing party, to investigate that if they think that could be an issue, ask questions and develop that if needed. If they don't do that, it's just going to be one more waiver, as you mentioned before, in how arbitration evolves, right? Well, before coming to the end, I would just like to ask you a very practical question. How can Brazilian practitioners buy your book? Where is it available? Is it available in ebook for immediate download? Yeah, well, there it is. That's your book, 11 Publishing, and what can you tell us about how to purchase the book?
Yes, sure. It is, in fact, available as a hard copy, as you see it currently on the screen, but it's also available as an ebook format, with the question you raised, and it's simply available at the website of the publisher, 11. So, yeah, it's easily accessible.
Well, thank you. Thank you so much. It has been a pleasure. It has been wonderful talking to you. Thank you for sharing this time with us and sharing all your knowledge about such an important topic. And I would like to now turn back to Cristina for closing. Thank you, Ilka.
Thank you.
Well, just finishing words also to thank you, Ilka. It was wonderful, very, very interesting insights. And I'm sure I just skipped through the book, but surely it's worth dedicating some time to read it. And so with that, I want to thank again the Arbitration Channel for our partnership, Fátima Bonassa Advogados, and Cesar for helping me and coordinating this program. So see you next time.
Thank you.
Bye.